Well, hello everyone, and welcome to this seminar on exiting your law practice. And I want to congratulate you for being here, because my goal today is to get you to be proactive about exiting your practice. So my goal is also to help you walk away with some tips of this is the beginning of starting to think about how to do that. Some of you may already be into the process of planning. Others of you, this may be brand new. And still others of you may be looking at this as a very long-term thing. You're a younger attorney looking at what do I need to be concerned with in the future. But the idea today is that we're going to give you some overview things to think about. And depending on, in an hour and a half, I can only do so much. What I'd like to do is take questions as we go. And the bar has indicated that if we have interest in this topic, that future seminars will focus on more details regarding this kind of a thing. With 25% of us estimated to be exiting the practice of law in the next 5 years or so, according to the bar statistics, this is a major hot topic. Not only for we attorneys who are thinking about exiting, but also for attorneys who are up and coming, the younger generations who are going to be thinking about either buying into our practices or taking over our practices or taking our clients, one or the other. So, as Sue mentioned, I am an attorney from Olympia. My practice focuses on business, real estate, and estate planning probate, because these are the areas that intersect so often in my clients' lives, and I assume in yours as well, many of yours. I've got involved in this because I have many business clients, small, medium business clients, some solo, some with larger businesses, who are in the process of are at that point if they need to start thinking about what we call succession planning. That word, succession planning, is not a popular word. It makes everybody yawn. So I say we because I work with a group of collaborative professionals, including accountants and business consultants, business brokers, on issues around the concept of succession planning. And I call it transition planning, because the transition could be a successor, but it might be something else. So let's start today with a couple of overview things. I'll take questions as we go. Please wait for Sue to bring the microphone to you if you're here with me today in at the WSBA CLE Center. And if you're online, please submit your questions to the online, the staff who are our webinar staff. Thank you very much to those folks. And they will get the question to me, and we will announce it, and then we'll respond. I'll also leave a very little bit of time at the very end if there are questions, and I invite any of you to talk to me afterwards. I will stick around and answer questions and chat with you about what you're thinking. And if any of you online in the webinar have questions, feel free to call me or email me. I'd be glad to chat with you about it. Okay, so let's dive in. Why do we transition out of our practice? There's the unanticipated reasons. The obvious is an unanticipated illness. But other issues such as divorce, or it could be some other type of unexpected event, perhaps having to take care of an aging parent, a spouse being deployed overseas, these things can also cause us to transition out of a practice. And then there are outside forces such as a natural disaster. For example, what if you were in New Orleans during the flood? Your practice is suddenly out of commission for a while. Then there are the anticipated reasons. Change of interest, you want to do something else. Retirement. Many in this room are probably in that path. We're headed in that direction. I'll be looking at retirement within 9 years. And the ultimate for all of us is death. No one expects death, so someone might say, well, that should be unanticipated. But in fact, we're all going to die. So let's be honest. It is an anticipated reason. So my goal is to get you to start looking at where are you in this frame of this overarching theme here. Where do you fit? We are all going to pass on. Rather than just waiting, we have choices. So the first option, we're going to look at our exit options. The first option that is frequently overlooked as a valid option is to just close your practice. I'm going to talk about this in greater detail. It is perfectly okay to just say, I'm done. I've had a good run at it. I've enjoyed it. And I want to just close my practice. Many of you who are solos will choose this path. But rather than having it happen by default, I hope to help you start thinking the process of planning so that you can do it in an orderly fashion and not wait till you die at your desk. Another one is to just leave. You want to leave your practice. This is typically where you're in partnership with others, whether it's an LLC, a sole proprietorship, or a traditional partnership. And in this case, the leaving can be either part of a strategy, or it can be suddenly you're just done. Again, we want you to start thinking about planning. I hope that you'll walk away with some tips to get you thinking about when might you want to do that. Another option is to sell, either to someone within your firm or to an outsider. And these are viable options too, even if you're a sole proprietor. So we'll talk about how to look at that for your practice and see whether that is an option for you. And last is the gifting. A gifting can happen for two reasons. One is perhaps you have a family member, the son, daughter, niece, nephew, cousin, whatever, who you want to gift to, who happens to be an attorney, of course. Or perhaps you have a key valued employee who's been with you for years, an associate, that you feel that has never quite been compensated the way you would have liked to, and perhaps this is an opportunity for you to gift all or a portion of your practice to that person. So there are good reasons to do gifting as well. As we look at the exit options, you have two broad choices. Those choices are to do nothing and let the chips fall where they may, or to plan. Now that word planning is something that we tend to say, we're busy. We're busy with the practice of law. That's what we love to do. That's what we do best. And the planning piece is something that if those of us who've been successful in our businesses and our practices know that planning is important. But the idea of planning for our departure is not high on our priority list. I'd like to change that for you. That's my goal today. So let's look at which choice is right for you. We're going to get into the choices in more detail. I'm going to start with an overview. The least amount of effort is the do nothing. It's the least amount of effort for you. But who is going to get stuck with dealing with that issue is your family members and your staff. If something happens to you in that unexpected category, if you die at your desk, your paralegal, your office assistant, your spouse, partner, family are going to be stuck with unwinding your practice and addressing that. Think about whether you really want to do that to them. And I've known a few attorneys, I'm sure you have too, who suddenly had an unexpected passing. They were solos, they had nothing in place, and that's exactly what happened. The dutiful paralegal carried on the practice as best she could for 6 months, winding things up, and then the doors were closed. The moderate effort is to close, leave, gift, or sell to an insider. This is going to take some effort. This will take some planning. And I point out that these last two efforts, the moderate effort and most effort, take planning, of course. The do nothing even takes some planning, because if nothing else, you have to plan not to do anything. And that planning not to do anything is going to weigh on your mind. So give it some thought. Do you really want to go that route? And if it doesn't weigh on your mind, it will weigh on your partner or spouse's mind. Okay, the most effort is going to be to sell to an outsider. And why is this the most effort? Because in order to sell to an outsider, you have to get your business positioned for a sale. You can't just say, oh yeah, I'm ready. You might be. Perhaps you are. Most businesses won't be. And we'll go into that in greater detail. So let's start with closing your practice. The reason I say this is a viable practice is that in the business world where I operate, when a business owner wants to sell a business, they want to get out of the business and they think they want to sell it, one of the things that a business consultant, myself, a business broker will look at is, do they own their job or do they own a business? Typically a solo individual in a small business owns their job, meaning they are an owner, but what they own is a job, a guaranteed income for themselves depending on the level of output they put in. Are you with me on this? So they put a level of output in and they put a level of effort into their business and they get a salary as a result of their effort. That's owning your job. Owning a business is owning something that you are a movable part. You can be taken out and somebody else can be plugged in. And think about your practice and whether your practices have either yourself, if you're a solo, or within your firm, if you're a small, medium firm, size firm, or larger firm even, who are the people within your firm that if that person exits for whatever reason, there's a big hole. Okay? So if you are choosing to close your practice, that is a valid choice. And if you're honest with yourself and you say, I own my job, this is probably the best choice for you. Not necessarily. You can turn that around. You can make a different choice. But this is a viable option, and it's a valid one, and it's an honorable one. The key is, how do you do it? So look at your time frame. The first thing you're going to look at is your time frame for closing your practice is generally 1 to 3 years. Things you want to think about, the big picture things, are referrals. Who are you going to refer your clients to? You've built up your practice I'm talking to some of you before the seminar today. Some of you have been in practice for 30, 40 years. You've built up clients that you care about, who care about you. You don't want to leave them in the lurch. You want them to have someone who will carry on for them and meet their needs. We are going to talk briefly when it comes up around the issue of part-time, going part-time, but I'm going to focus now on the true exit for today, just focus on that as the primary, and then there can be variations on this theme. So going back to the referrals, you want to think about strategically, if you're 1 to 3 years out, start thinking about who are those people. Generally, they're not going to be your peers at your age group. They're going to be younger attorneys who you respect and who you think have a similar philosophy to how you've practiced law and who are competent and who you think would do a good job for your clients. And so what you would want to do is give your clients choices rather than just say, I'm giving all my clients to Jane. Okay, well, no, I've got a list with Jane and Harold and Phyllis and Paul. Great, let them pick who those people are. And then they can go make their choice based on interviewing. And you can encourage your clients to interview. I know an attorney recently who closed her practice in Olympia, and that's exactly what she did. She gave a list of attorneys, including my firm, and clients would call up saying, hi, I'm interviewing. That's great. You have a chat with them, and they say, okay, great. You sound like you'd be a good fit, or not. So that will be one key thing you want to be thinking about. Another thing is the financial piece. If you're going to close your practice, obviously there are things, maybe perhaps a line of credit, equipment leases, your building lease if you don't own your building. So how are you going to address those issues? Like you want to close in 3 years and your lease is for 5 years, or let's say your lease is renewing next year and you think you want to close in 5 years, then you need to renegotiate your lease for either a shorter or a longer period of time, maybe a 5-year lease with 1-year renewal if you think you're going to be closing your practice. So give some thought to things like that, things like copier leases that are typically 5 years. You want to look at those financial components so that when you close your practice, all of your loose ends are tied up. And you have no financial obligations, and all you're doing is reaping any receivables that still may be drifting in, okay? Another thing to think about is your professional liability coverage. If you are 1 to 3 years out, you want to be thinking about reducing the types of cases that you take that may bear some higher risk. Because once you'll recall that for most of our professional liability coverage, it ends when we end our practice, and then you have to pay typically an enormous amount to keep that going in case claims are made after the fact. So you want to think about, how am I going to handle that liability? You can either say, I'll just take my chances, but if that's the case, then what you want to do is you make sure before you close your doors that that you have limited your exposure as much as possible. And that limiting exposure we do as we go. We pick cases that are good cases and we are competently representing folks, but at the same time, you can also make a conscious choice that perhaps you won't engage in that litigation that sounds really fascinating because I really think I need to be exiting from this type of work because it carries greater liability than, say, doing this other type of work. Okay? So those are some of the things you want to be looking at for closing your practice. There are many other things, such as what if I want to go part-time? What if I want to bring on someone? And we're going to kind of fold those concepts into our conversation this morning. Are you with me so far? Okay, good. Let's talk about leaving your practice. Leaving your practice, I purposely use the word leaving rather than selling, whatever, because you're not necessarily leaving your practice because you are retiring. It could be because of a family member, an unexpected issue that comes up, family member is ill, you want to do something different, and you just want to leave. So your considerations are different. And again, if you are planning to leave, let's say you want to go off and you want to work in the Peace Corps, or you want to retire in 1 to 3 years, or you want to become a writer of mystery novels. Whatever your reason for wanting to leave a practice, when I say leaving a practice, I'm implying there's more than one of you, more than one attorney in your firm. You have bigger considerations, or additional considerations, I should say. And the considerations include competency of the people who are following in your footsteps, relationships of the people you're leaving behind. We're going to go into this in a bit more detail in a few minutes. Valuation, because how will your interest in the business be valued? Financial, we talked about some of those issues, and I'll go into more detail with those. And then there's the legal issue of how am I going to structure my agreements so that it's clear what I'm trying to do. Many of us are going to semi-retire. I plan to go part-time at age 66. I like what I do, I enjoy it, and I'm not ready to retire, but I plan to go part-time 66 to 70. That's an example of where I'm going to need to structure that as the time gets closer, to have a very solid agreement about what are my roles, what are my duties, how many hours will I be working. And I've already told the attorneys in my office that when I retire and I'm tottering around, I want you to tell me to get out of the way. If I'm tottering, I know Jess is coming in today, and if I'm in the way, I want to be told, because you get out of touch when you're not there all the time. So there are some things you're going to want to set up as you're thinking about going part-time. I also heard of another creative one this morning when we were getting ready for the seminar, that there might be, there's other creative things you can do. Align with another firm as of counsel, or perhaps have work under another firm rather than on your own so that you don't have the overhead. So there are many creative things you can do should you choose to go part-time. I don't have time to focus on those issues today, so I'm going to continue to focus on the big picture stuff. Next, gifting or selling to an employee. Your time frame should actually be 3 to 10 years on this. It could be shorter if you're desperate or if something unexpected happens, but generally speaking, you want to plan 3 to 10 years. Why? Because the person that you are selling to an employee, is generally someone younger than you. It should be. If you are of retirement age or close to it, you want that next generation to come on board. And they need to be trained not only in the law to be able to handle your clients, and that takes experience, maturity, just years at doing it, years of practice, but also they need to be trained on how to manage the practice. I'm presuming that anybody in this room is here, and again, I congratulate you for being here, because this tells me that you are proactive and that you are good business people, because you care about what happens to your practice and your clients, right? You're not going to get that. You got that through the School of Hard Knocks, most of us. Some of us may have an MBA or some other advanced learning in business management and taken lots of classes, but generally we get this by making mistakes, right? At least I did. I learned to be a great businesswoman by making a lot of mistakes along the way and learning from my clients' mistakes. So that does not come overnight. And to the extent that I had someone mentoring me on the business end, I would have made fewer mistakes. So if you're planning on bringing an employee on, the time frame for getting them up to speed is going to be approximately 3 to 10 years, so that they can basically walk into your shoes as the managing attorney in the firm, if that's your plan for them. So again, your considerations are competency, relationships, valuation, financial, and legal. So very similar concept, but the time frame different than just leaving. And partly because when you're leaving your firm, generally you're going to leave your clients with the firm. So your clients are taken care of. They'll be dispersed among the next generation or maybe your colleagues. And so you'll know that they'll be taken care of. But you don't have to do any of the wrap-up. Versus if you are actually closing your doors, there's a lot of wrap-up to do. And if you are gifting or selling to employee, you've got a lot of time, you've got a lot of wrap-up, not at the other end of like, what do I do with my files and where do I put my original wills? But what you have is training of the people who are coming behind you. And that mentoring and training is critical to their success. And you know I'm of the right age. I've got my reading glasses with me. So, selling to a stranger. Our time frame here is 3 to 5 years. The considerations are the same as selling or gifting to an employee, but we have an added piece here. And the question is, are you going to sell it yourself, or are you going to hire a business broker to sell it for you? And you can certainly sell it yourself. There's ways to do it. But you might be happier having a business broker just handle the transaction for you, find someone, and call it good. The benefit of that is that they're going to be aggressive in, just like selling a house by yourself versus hiring a broker to do it for you. It's going to take more effort. It's going to take effort to get your business ready for sale, and unless you want to put a lot of effort into into that, then go ahead and hire a broker. There are some competent brokers out there who can help you sell a professional practice. All right, so let's now dive into the details. Valuing your practice. My premise on valuing your practice is that two things need to happen before you even begin to try to get a good value in your practice. There are a lot of things you can do that are preliminary, and we'll talk about those. So first thing is that your financials must be pristine before you actually have a formal business valuation. I say pristine. What do I mean by that? What that means is that an accountant and you and your bookkeeper have a very clear understanding of all of your categories of expenses, income, your balance sheet is pristine. There's not these goofy categories. Everything is clean and tidy. Why? Because the ability to finance the purchase of your business is determined by the strength of your financials, and the ability to sell your business is going to be judged by the strength of your financials. So if you've had the bookkeeper who kind of knows QuickBooks for years, or the bookkeeper changing accounting staff constantly in your firm, you want to have this evaluated by somebody independent who can evaluate whether your financials make sense and whether they are solid. And if you want to talk about this, I'm glad to chat with anyone about this topic. It's one of my pet peeves is that if you go to a bank and you say you want a line of credit, bankers look at something very different than you and I look at in our bottom line every month. We're looking at our profit or loss. We're looking at our expenses. Where are we in terms of, are we on budget? Are we not on budget? But bankers look at ratios. And unless you're very familiar with how bankers look at these ratios, and unless your ratios are good and solid and fall within the range of what's expected for a law firm, then your buyer will not be able to get financing to buy, which changes the scenario for you in terms of selling. So we'll discuss owner financing, but it comes back to this whole piece of the financials. Not only do you as a business owner need to understand your financials, if you don't, there are many people out there competent who will teach you what to look for, but learning what these ratios mean and understanding how these ratios can make a difference in valuing your business is critical. So your financials must be pristine. The second thing is operations must be documented. If you are owning your job, you're probably closing your doors. But if you own your business and you want to sell that business, you've got to have documented operations. This means your policies, your procedures, how your staff do things have to be in place, because the idea, remember, we're going to take you out and put somebody else in. That person needs to go in and know that the staff knows what to do. They're not going to be, oh yeah, how do we open a file, or how do we close that account in the trust programming? These are things that should happen in any firm in general, but they can be overlooked in even a medium or larger firm. So operations must be documented. If you need help with this kind of a thing, typically a good business consultant can help you get these in place. And a good office manager, or if you have a good staff member who is a senior paralegal or something like that, or senior legal assistant, they can help put these policies and procedures into place. But you would need those in place in order to be able to sell your business to an outsider. So then let's get into, where do we find someone to value a law practice? You have really several choices, and before we actually value it, you can get a ballpark idea. I would recommend getting a ballpark idea of what your practice is worth, typically from a business broker. A good business broker will be able to just give you a ballpark idea of what do you have, what's your income, expenses, without even reviewing your financials. They'll interview you in terms of what are your, do you have operations manuals in place and the like. So when I'm looking at this, usually you could get a ballpark idea up front, work with the broker to kind of figure out what's missing, and then fill in those gaps before you actually have a formal valuation. That would be typically what I would recommend for anyone thinking about selling a business. So the appraisal or valuation is typically done by a CPA. It could be done by an economist, business broker, or business consultant. There are probably others out there I haven't mentioned, but these are the key people who would typically value a business. When I say a CPA, not every CPA will do this, but some CPAs specialize in business valuations. You want to find one who does professions. And I would recommend that you get familiar with the various methods of valuing a professional practice. You can do this by going online. You can do this by reading a couple of books. And the idea is you don't need to spend a lot of time on it, but you need to be able to speak intelligently with your broker, or whoever is valuing the business, to be able to say, how are you intending to value my practice and why? You want to know how and why. Typically, for a professional practice, it's often the income approach. So what that means is that they're going to look at how much have you drawn out of the business over the years? What is your annual salary? And what perhaps might be your any distributions to you if you're a sub-S corporation. So they look at how much money have you taken out. So if you have a $150,000 net to the owner of the business over the past 10 years, that's great. That gives them something to work with. If you've got $30,000 net over the past 10 years, that's a real problem. So the real question is, where is the benefit to the owner? Perhaps the owner is using a lot of deductions. The owner works from home, has a home interest deduction, all of those kinds of things. Those things can be taken into consideration, but generally speaking, you need to understand roughly the different ways of possibly valuing a professional practice so that you can speak intelligently with the person who is doing the valuation. Okay. So again, my two-step process in this would be get a ballpark idea of whether you're even in a good position to have your business valued, and some of you will be. Many of you may be in a great position to say, yeah, let's get a business valuation right off. But then there's another group of us who might not be in that position, and so you need to do some work before you get there. All right, let's look at the legal considerations for a sale. If you're going to sell your practice, you have two choices. Either sell your practice, meaning the entire business. You're an LLC, you're a sub-S, even if you're a sole proprietor, or you are going to sell the assets. So this is where closing your practice, you're going to be selling your assets. If you intend to have the practice continue, you will probably want the practice continue under the name of your corporation or LLC or PLLC, but the person who buys it may really just want the assets and your client base, not everything else. So they might want your office, your client base, but they may not want to keep your name. Well, the name can be changed, but are they buying the entity or are they buying the assets? That is an important point, partly because of liability and tax. If they buy the business, they are taking over potential liability. So that former client who sues 2 years from now, that's typically on the business's head, not on yours personally, typically. And versus if you essentially sell the assets but not the business, well then that goes with you. So those are issues that need to be addressed in the buy-sell agreement. Typical documentation in a sale, of course, would be a purchase and sale agreement. And you're going to have that whether you are selling to someone on the outside, selling to someone on the inside, or even if you are leaving your business, you're leaving a firm where you have partners. You need to have a documented agreement as to when and why and how much. Obviously, there'll be a bill of sale, and the bill of sale will need to reflect whether you're selling the business or just the assets, and a value for how much those assets are, so you can apportion to any tax issues such as sales tax. You don't want to overlook the debt associated with a business. That if you, let's say that in 5 years you're going to retire, but your lease is a 7-year lease, it will run out in 7 years. You want to look at your leases, for example, on your copiers, on your larger equipment, on your building, if you're leasing your building, and did you sign a personal guarantee? If you've got a personal guarantee on there, then you're liable beyond the time frame that you exit your practice. So you might want to try to renegotiate that. And if at a minimum you want to do an assignment and assumption, get the landlord to allow the buyer to assume the lease and also consent to the assignment. Yes.
Is there any particular legal entity that you should form in order to sell? Right
if I could get you to turn that microphone a little bit towards your mouth. Thank you.
Right now I am a sole proprietor, and
yes.
If I'm interested in selling the practice, is it better to establish some other type of legal entity, either a personal service corporation, LLC? Is there any advantages or disadvantages in any particular entity that you use?
That's a good question. All right, so I'll just repeat the question since we're, did that translate? No, okay. So the question is, I'm a sole
It
proprietor.
actually did translate. I'm sorry, I was shaking my
It
head.
did?
You don't
Okay.
need to repeat.
Great, thank you. Thank you. Okay, so in that case, the first thing I would do is first check and see whether your practice is viable for sale. Do you own your job or do you own a business? If you actually own a practice that is viable for sale, then yes, I would probably recommend you convert it to a sub-S or to a PLLC. And the reason I would do that is that then you can typically sell the business, not just the assets. And then, but you also want to take into consideration the time frame. If you're talking a year from now, 2 years from now, that's a different issue. If you're talking 3-5 years, then it would make sense to do that conversion more so because your lease is probably in your sole name. Your copier lease is probably in your sole name. Any of those larger items that you may have, and so that liability would still be with you personally. So you'd have to assign that to your new entity. So you could do it for sure, but there are just little pieces that you want to make sure you don't overlook in that process. And the reason to do that is that it's usually easier to sell the business when it's an LLC or a subchapter S. It's more viable as a sale. But that would be something that I would have it's going to be case by case, have you talk with a business broker and say, this is what I'm thinking of doing, and would you recommend that? Okay. All right, assumption of debt. Along the same lines, if perhaps you have a business line of credit, most of us do for those times when we have unusual expenses, perhaps for litigation or the like, and or just to deal with cash flow. So you've got a line of credit. Typically, you've personally guaranteed that, typically. And so you want to look at other debt. How about your vendors? All of your vendor accounts, if you're a sole proprietor, for example, your vendor accounts are in your name personally, and they're attached to your Social Security number. So if you sell your practice, this is another reason why you might want to change everything over. You want to change your accounts to the name of an entity so they're no longer in your name. Because what if you sell your practice and then the person comes in and they aren't successful? And as a result, you've now transferred all your accounts which are still in your name. And they're going down the tubes, and guess what? You're going down with them. So these are some of the financial and legal considerations for you to start looking at if you're getting ready to sell. The other is apportionment of liability. It's not uncommon when a sale of a business occurs, depending on the kind of practice, typically professional practice, there's going to be some apportionment of liability. Why should I, if I'm buying your practice, take on the liability that you incurred? If I'm an outsider, I'm not going to want to take on your liability. I'm going to want you to keep that liability if somebody sues the firm after you depart. At the same time, if I am buying within a firm, that's assumed to be okay because the firm has the liability, and the liability, that's partly why if you're in a firm and you are buying into a practice, it continues with the firm. It's a little bit of a different model. So a sole proprietor versus a firm, you might find that there are, or versus a sub-S or an LLC, you might find that the liability apportionment is a little different. So you want to give some thought to that, how that should work that's fair for everybody involved. And of course, I mentioned the professional liability piece. Some professional firms will require the business to maintain that insurance for them or cover them for a period of years afterwards. So there are some tricks here, but it requires some research. It requires talking to your liability carriers and talking to them about, okay, we've got somebody retiring in 3 years. How is that going to impact our covering the work if claims are made for them afterwards? Okay. Financial considerations. The biggest one is the financing. Typically, you're selling to someone who is younger than you. And if, like many law school graduates today, they come out with very large student loan debts, and they're busy raising families, and they're trying to buy houses, and do all of those things. They may not have disposable cash to be able to pay you for your interest in the firm. So the reality is, you're probably going to get paid over time, unless the firm is solid enough where the buyer can get financing. Now, there are a couple different things you can do. One is you can do a buy-in, basically kind of a sweat equity buy-in over a period of years, which is why, remember I said 3 to 10 years? This is partly why, that perhaps they can keep their salary frozen at a certain level and be buying in gradually into the business over a period of years. And that way they have built up the equity, not the whole thing perhaps, but they have built up some equity in the business by the time you're ready to exit. So that's one possibility. Another possibility is that they can get financing, but again, this goes back to how do we value your business? Are your financials in pristine condition? Do you have those operations manuals in place? Do you have a solid business valuation that gives a good, solid valuation of your business that buyer can take to a bank and say, look, I'm buying this wonderful law practice. Give me enough money to be able to pay off the owner. The idea is you want to get your money up front. We'll talk about owner financing in a minute. Okay? So those are considerations. Another is taxes. When you leave your practice, if you're a solo, that tax liability goes with you. However, the IRS and the state also look at the idea that if someone is substantially carrying on your practice after you leave, they're on the hook for any taxes you didn't pay. So one of the key things in having pristine financials is having all of your taxes paid. Now, I'm assuming most of us pay our B&O on time, and we pay our federal withholding and our state withholding taxes on time. That's good business practices, and I'm assuming because you're here, you must be proactive and you're doing those things. But you'd be surprised at the number of businesses that don't, and they get in trouble with the IRS and with the state and with L&I because they haven't paid their taxes. And so what happens in a business sale is that debt goes with the business if it's an LLC or if it's a sub-S corporation. But if it is a sole proprietorship, it stays with you. And then if you sell the business, you sell your practice, regardless of the entity, and let's say the new person comes in and forms a new entity and they basically take your assets. If they can if the IRS or if the state can show that they are substantially operating your practice, then they can also be held liable. There are some things you can do at the state level to disclaim that, but early on when you first take over the business, but there's no guarantee, and there's nothing you can do at the federal level other than fight it. So you want to, if you're planning on exiting, you've got to make sure your taxes are squeaky clean. And it's not just your business taxes. The next thing you also need to look at is your personal taxes. If you're selling your business, will there be a capital gain? And this is something to discuss with your accountant. And again, having the pristine financials will help determine whether you are going to have any kind of a capital gain on the sale. So as you structure your financing, we'll talk about that in a minute, you're going to want to look at payments over time are typically better than a lump sum, and there's a trade-off here. That will be obvious in a minute. I mentioned the vendor accounts. If you are transitioning out of your business, you want to absolutely make sure that you don't have any of those accounts with a personal guarantee or in your sole name. And you know how it is, your staff call up and set up your account with PSE, and they give your name. They didn't realize they were supposed to put the firm name on. They gave your Social Security number instead of the firm EIN, and now this counts in your personal name, and you sign the checks every month, and someone hasn't changed it. And so it's really critical to go through each of your vendor accounts. All of my vendor accounts are in the name of my corporation. They're not in my name. None of them are in my personal name. And none of them are attached to my Social Security number, and I have no personal guarantee on any of them. But it's not uncommon to have that be you've seen the forms. You're signing off on this, and they don't have it set up for a corporation or for PLLC, and so you sign your name individually without realizing you've just given a personal guarantee. So you want to check that out very carefully, because again, when you sell, if that business goes under, they're going to come after you. They're not going to come after the business if the account's in your name. So then, providing for a spouse or partner. One of the things that I hope most of you have is key person insurance, or key man insurance, it used to be called. I call it key person insurance. And this is insurance that your business owns on your life. For those of you who are younger, please get it. For those of you who have it, great. And for those of you who don't, okay, fine. You may not be able to get it at this point if you're close to exiting your practice. But key person insurance for the next generation, if you are an older attorney and you have associates in your office, you can get key person insurance on their life. And so if one of them unexpectedly passes on, then that money comes to the firm and can cover the expense of, oh my gosh, and we now have to hire somebody. We don't have the income from that associate, and now we have to hire somebody to fill their shoes immediately. So this is very critical for those of you who are 10 years or out or more. If you can still get key person insurance, I'd encourage you to do it. If you suddenly die in your practice, your firm will be able to continue on. Your clients will be served. Your staff will be able to get paid while they do either an orderly wrap-up or while your associates or others take over your firm. It allows your estate to be paid for your firm without having to put money in to take care of those loose ends themselves. Does that make sense? So I have it on myself and any associate who works for me. So that if there's it's only, of course, for death. It's not for departure, other reasons, but it's a comfort, and it's relatively cheap. Providing for your spouse or partner, if you're in a firm, I assume you have an operating agreement, shareholders agreement, or partnership agreement. If you're in a firm with partners or members or shareholders, you should. If you don't, make sure you get one of those in place. This is the shoemaker's kids going barefoot. You know better. Do it. And that should provide for a withdrawal provision. Make sure, go back and look through your shareholders agreements, those of you who do have those in place. Look at what it says about two things. One is valuation. Is there anything in there about valuation? How will the firm be valued? How will your interest be valued? And number two, how will you withdraw? Is there an orderly withdrawal process? And is there a process for someone who just wants to depart, or retire, or die? There should have all three contingencies covered. And I have a fourth, which I call the flake-out provision. I put this in all of my agreements, and that is where somebody just disappears. I practiced in a firm back east for a while, and one of our attorneys just basically disappeared. And he's having a rough time. It was a midlife crisis, and that happens. I'm sure some of you have either experienced that with partners or know people who've had that experience. But it's incredibly disruptive to a firm. Suddenly somebody who is productive is not productive and pulling their weight, yet they still own a portion of the business. So I encourage you to have in your agreements what I call the flake-out provision, that somebody just basically disappears. They want to go to South America and sail a boat for a while, so that you can ask them to leave. And at the same time that you can figure out an orderly way to value the business and get them out of the practice. That is helping to provide for your spouse or your partner by providing that if something happens to you, that your firm will buy out your interest if you die. You want to make sure that your shareholders agreement provides for what happens if you die, so that your spouse or partner will not be left in the lurch there. And of course, there's another aspect, which is estate planning. In your estate planning, what you want to look at is that if you intend to gift your interest to a family member, like a son or daughter, don't make the assumption that will just magically happen. The other children in the family may take exception to the fact that they have now, son number 2 has now been gifted with a law practice worth $500,000, and they get nothing, or they get substantially less. So do your will if you are intending this as a gift, and just in case you do pass on, and that way you can make sure that there's no misunderstanding. And typically you're going to want to have that deducted from other assets. And if, for example, let's say your estate is not something where you'd have enough to give to all 3 kids in equal shares, then maybe that child number 2 gets some of it as a gift and the rest as has to buy over time. But have that provided for. Next is the competency and relationship considerations. These are, frankly, some of my favorite things to talk about because they get in the warm and fuzzy side of law. We are thinking people. We could not do the jobs we do if we did not have a very solid ability to do analytical, critical thinking. At the same time, we also, especially those of us in smaller practices, we tend to be people. We like working with clients. We care about our clients. We care about relationships. So I like to always characterize it that I bring my head and my heart to my practice. And I think most of you do too. So as we bring our head and heart to practice, we need to look at the realities of relationships. And the day-to-day practice, we have all had these situations of where there was an issue, we didn't want to deal with it, we're busy, but ultimately, if you don't deal with it, does it what? Does it fester? Does it eventually come to a head, and eventually you have to deal with it, right? So this is a situation where I want you to look at this proactively and with the steely-eyed stare of what's the reality here. if you do bring in that son, whose number 2 son comes into your practice, and he's going to take over your practice, and how is that going to be perceived by your associate who's been with you for 10 years? How about your staff who remember him when he was 2? How about the interaction of he's a millennial and everyone else in the firm is a boomer? Those are issues that you're going to really have to grapple with when you're considering things like the relationships among your firm members. And the same thing applies for if you are looking at bringing someone in from the outside. How is this person going to fit? Now, in some ways, you might say, well, that's not my problem. And if you're getting your money up front, that's true. It's not your problem. But if you are not getting your money up front, it is your problem, because if you're getting paid over time, the success of your practice and your ability to get paid is totally dependent on the competency of your successor and how your staff and clients relate to that person. Okay? So that's why this is a really key piece, not to be overlooked. So let's look at competency first. Competency, obviously, even if you're bringing someone in from the outside, when you're bringing someone in from the outside, it's important to know that they really can practice law, that they really know what they're doing, given the level, the kinds of clients you have and what they want to do, and what your clients need. So you're looking for obviously somebody who is competent in the areas that you practice in, and also someone who has a philosophy, I would say, similar to yours. And again, this is self-interest. This is not only self-interest for yourself, it's self-interest for your clients. You want your clients to be well taken care of. So the competency of this individual is not just law. It's also their competency in running a business. Have they ever practiced before? Have they ever run a business before? Do they have any training in running a business? And you will talk to many attorneys who've never, other than contracts in law school, have never taken a business class or have never studied it. So do they have any idea what they're doing? And for those of you who practice business law, you know that you get someone into your office and they want to start a business and it's a great idea, and you know that they will never be successful unless they get some help learning some basic things, like how to set up the books and how to read financials and how to have operations manuals and those things. And so you refer them out to good resources who you hope that they will follow, and you know that if they follow that path, they're going to be successful, and you know that if they don't, they will probably fail. And there's not a heck of a lot you can do other than dissuade them from wasting their time and money on starting a business unless they're serious about it. So we've all run into clients like that, and the same applies for that gung-ho attorney who wants to buy your firm. That person may be competent as an attorney, but if they're not competent to run the business, you really want to look at that. You really want to look at that. That's why I go back to 3 to 10 years. If they're serious about it and they're working within your firm, you can get them those competencies, not only in law, but in operating the business. But if they are coming in from the outside and they're not competent, you can say no. You do not have to sell to this person. You can say, you know, this isn't the right fit for my clients, and it's not the right fit for me to get paid over time, okay? So the second component of this is the how will your staff and clients interact with your successor. That, again, you might have generational differences, which clients who are of the same age group that you are might be fine with that, but some may not. And so ideally, if you're truly planning for a long-term exit, 10 years, if you've got 10 years to do this, you can plan this ahead of time by saying, okay, I'm going to bring in somebody who's an X, and I'm going to bring somebody who's a millennial. And now you've got your generations covered, and here I am, the boomer. And frankly, that's what I'm doing in my firm. So that we have the generations covered, and as I retire, the next generation takes over. As she retires, the next takes over, that kind of thing. So the plan for this is teaching competency and being willing to mentor and take that time to mentor. And many of us were mentored. I certainly was. I had wonderful mentors, and many of us do mentor. It is, I think you've probably, I can probably tell whether there are any, this tends to be a generational thing. I find that many of the younger generation attorneys have not had mentors and are not being mentored. When you work in a small or solo practice, you have the greatest opportunity to be mentored and to do mentoring. And this is something that we as professionals need to do. We need to do that for the people coming behind us so that they will be competent and they will be able to work and take over our clients and take over our practices. And so as we're looking at how will your staff and clients interact with your successor, you want to look at things like generational differences. You want to look at things like personalities. And if you are the quiet personality and you've got somebody who's a live wire, that may be great, but that's not what your clients are used to. So it doesn't mean you have to find a clone. That would be nice, but it doesn't mean you have to find a clone. But you want to be sensitive to finding someone who's going to, you think, fit within your practice, yet be their own person. Okay. Let's talk about owner financing. If you are going to do owner financing, you can now see why I mentioned that you have to have someone competent follow you as a successor so that you can get your money, because owner financing means you're not getting money up front. If you have to do it, get as much up front as possible. Make sure the payment terms are reasonable. You might want to structure this so that the payments increase over time, because keep in mind you're exiting, so a good chunk of the income is going with you. Even if you're going part-time, a good chunk of the money that you bring into the firm is going with you. And so consequently, that gap will be there. So the new owner will now have to try to figure out how to fill that gap. So make the payment terms reasonable, especially in the first 2 or 3 years. Then you can increase the payments. A payment plan over time to you will generally be better for you from a tax perspective. You're not getting all of your money up front, but here's the trade-off. You're now taking the risk that the firm will be successful, and that the person who bought your firm will actually still be there. If you are going to do financing over time, I would encourage you to get a promissory note with a personal guarantee. Banks require it, why not you? You're a bank. You're being a bank in this instance. And ideally, of course, we want you to have pristine financials so that the lender will lend to the person who's buying, but in the case that isn't happening for whatever reason, it may not be because of you. It could be because of the creditworthiness of your buyer. Your buyer has the ability, but your buyer also has a house payment, has child support, has student loans, and they can't, on top of that, justify being able to buy into your practice. But they can buy the practice and then take it out of the practice can actually buy your interest in the business rather than them personally. So, but I would have a personal guarantee. I would definitely have a security agreement and or a UCC1 to secure accounts receivable, inventory, assets, anything that the firm owns. Make sure you have a security agreement to secure your interest in the note. And you want to look very carefully whether you want the right to be able to come back in and take over that practice if things go awry. And you might want to reserve that right to do that in the first 2-3 years. You don't want to be doing this when you're 75. But typically on the default, if it's a business sale, the owner often reserves the right to come back in and take over the business, because then they can build it back up and sell it again. I see this in restaurants all the time. Maybe many of you do also. So in that kind of a situation, you want to look at, do you want that right? You can always put it in and not exercise it. That would be my take on it. And then look for additional security. For example, second mortgage on a primary residence, something along those lines, if available. Okay. Okay, so now we get into when to start thinking about an exit strategy. You should start thinking about your exit strategy when your practice provides the sole or majority support for your family. So for those of you who are younger, newer attorneys, don't be waiting till you're 50. Do it now, because you might decide that at 45 that you want to do something different. Those of you who are middle-aged, you want to be thinking about it now. And those of you who are about to retire, you need to be thinking about it yesterday. So the idea here is that it should be part of good business planning is always to have an exit strategy. And the ultimate exit strategy is you unexpectedly die. So think and a good way to look at this would be to say, well, if I'm going to develop an exit strategy, what would I do if I killed over dead tomorrow? What would my firm do? Would it be able to carry on without me? And if the answer is yes, good job, you've done it. But if the answer is no, then that's where you need to do some work. Don't leave that for your family and staff to have to try to deal with. Another example would be you have an associate you don't want to lose. That's a great time to be planning an exit strategy. When here I'm talking about a planned exit strategy, not the unexpected death strategy. So you've got an associate you don't want to lose, and here this associate is someone who has been a great employee and wants to take over the business, but they don't perhaps have the business skills, and they're not fully at that full competence level yet. They're still learning the practice of law. So that would be another example of where you could then put in a mentoring and an exit strategy that would include that person. It might include an option to purchase. It might include a gradual buy-in. If you're going to do a gradual buy-in, one thing to think about is to wait because I've had this happen with many of my business clients where they say, oh, I'm going to sell to Joe, who's a great plumber. I'm a plumber, and he's my number one person. Well, then something happens and Joe doesn't end up buying, and he's now a minority interest holder in my client's business. So what I recommend instead of that is to basically say that you buy into the business and you get the voting right while you were there. You get your rights, but your interest is held in trust, and until such time as you've passed a benchmark, maybe 5 years, 10 years, whatever, or until the retirement. So that you can be assured that if the person decides that I've changed my mind, I want to go travel through Europe and I don't want to practice law ever again, that you're now not stuck trying to deal with a minority interest in your business that you've now just either gifted or sold or done some sweat equity, and you now have to buy out that person. And so there are ways of addressing that, very many creative ways of doing this, and so it's almost as unlimited as what your imagination is. It's just a matter of figure out what works and then design your documents around it. I tell my business clients this, I'm sure you do the same, that rather than me saying it fits in this model, this form, start with the idea of what do you want to do? What makes sense? What works for you? And everybody, every person in this room and in our webinar listening in, each of you have a unique way of approaching your practice. And so how you do this is going to make, you do what makes sense for you. And then when you do what makes sense for you, you structure the agreement and the form around that, rather than trying to fit yourself in a box that doesn't fit. Okay, when else to start thinking about an exit strategy is you are 10 years or less from your desired retirement or withdrawal age. Okay, you really need to be focusing on this, 10 years or less. I'm year 9, so I'm totally involved in this process now. And you either have or anticipate health issues. Okay, if you've been given a terminal diagnosis, that's a no-brainer. If you anticipate a health issue, if every single male in your family dies from a heart attack by age 62 and you're 60, you need to be thinking about this. Don't put blinders on, please. And if you have other types of health issues that you know are likely to hit you because of your genetics, then plan for that. You can plan around that, but it's about planning. So transition planning is the process of deciding and identifying and deciding, first, whether you want to close, sell, gift, or simply leave your business. What do you want to do? Why you want to and if you choose to have someone take over, you want to go deeply into why you want someone to take over your practice. So what I'm asking you to do here is get conscious about this. Make this a conscious choice in your life. Don't make this by default. So let's go back to identifying whether you want to close, sell, gift, or simply leave. Just want to get out. There are ramifications of all these things. And it is, as I mentioned, it's perfectly acceptable to close your doors. I just want you to be thinking about doing it in a conscious manner rather than leaving it to chance or leaving it to just fate. And get quiet. Go someplace that speaks to you. I don't care if it's on the golf course, in the woods, on your sailboat, in a pub. I don't care where it is, but get to a place where you can sit with yourself. These first 2 questions are critical. What do you want to do? Just like when you thought about, what do I want to do with my life? This is about, what do I do about exiting? Something has been a major impact in my life, my business, my profession. Get quiet and think about which aspect works for you. And as you're thinking about the first question, the second is critical. Why do you want someone to take over? Do you want someone to take over because you're concerned for your clients? Or is it more of your ego? And it's okay. I just want you to look at it and recognize that. Do you feel like you need to leave a legacy? I've created an empire here and I want to pass it on to someone. That's okay. If you think you've created something that's just beautiful and wonderful and it works and somebody would be great in it, then that's important to know. But I also want you to think about your energy level. How much time do you have to devote to this? We'll talk about the planning aspect in a minute. But remember our earlier slide of what's going to take the most planning, what's going to take the least planning. The do nothing takes the least. The selling to an outsider takes the most, and everything else is in between. It's going to take some planning and action on your part. And if you don't have the energy to do that, then just to recognize it, and recognize that your best choice would be to just close your doors. It's going to be of the moderate effort, that's the least amount of effort, that one. Bringing someone up from within, finding someone to bring into your firm and train them, get them to where they buy your practice, is going to take more effort than just closing your doors. So look at who will succeed you. Make a list of the qualities of the person you're looking for. This is not going to be just by that gut instinct. Be practical. Write this down. Just like if you're looking for a quality in an associate or in a staff member, who do you want to succeed you? Does this person need to be an introvert? Can they be an extrovert? Do they need to be a rainmaker? Do they need to be someone who has a warm and fuzzy side? Do they need to be all analytical? What are you looking for? Not only their personalities, but what qualities? What do they bring? What experience do they have? What gifts do they bring to your practice? Look at who that person should be to fit into when we pull you out as that chess piece and put them in, how are they going to fit? Also, think of the vision of what will it look like after you're gone? Because remember, you're not there perhaps, but you're getting money from this venture. What do you want it to look like? And one of the biggest things, one of my mentors, actually this was when I worked in state government, I was a government attorney for a number of years, and my mentor said to me when I took over an office that was greatly disheveled, that needed major overhauling, she said, one of the things you need to remember is that you're going to do a great job overhauling this, but when you leave, you need to leave it behind. And you need to walk away and not look back. You need to be able to release it. So this is the old release attachment to outcome. Once you have this kind of interest in making sure it's successful, but the best you can do is make sure you pick the best person or people to take over, and that they are well-trained and competent, and that they're going to get along with people generally so that they can take over the business. But at that point, you wash your hands. You need to walk away. You can offer to be there as a mentor. You can offer to work part-time and try to help with the transition. There are things you can do. But ultimately, you need to let go. You need to move on with your life. And you need to not be micromanaging from beyond the grave, if you will. Okay? Then the when. For many of us, that date is exact, and for others it's fluid. Some people may say, kind of between 55 and 60 I want to retire, or between 62 and 66, or between 65 and 70. That's fine. But the when is going to be important because it gives you an idea of how far back do you need to go. We have some questions from our...
Yes, thank you. We have two. Let me ask them one at a time. Is the statement that tail liability insurance for the departing attorney is expensive true for a situation when the firm continues to carry coverage on all cases in the firm?
I'm not an expert in this area, but I can tell you, I'm raising the issue that you need to check it out. So it tends to be less expensive. My understanding is, just from my own checking into this, is that it is less expensive if the firm continues than if the departing if you get it for yourself, if you're a sole practitioner and you just want to carry it for yourself after the fact.
Second question. What WSBA notices are required to be given, such as reduced practice levels and inactive status? Now, we realize that you're not representing WSBA, but can you talk about this?
This is something I know the bar is looking at right now, and I'm not sure. I believe we have some proposed rules, kind of draft rules on this, maybe. But the bar is looking at this. Right now, there's no specific. I'm not aware of any specific rule that says you must give this XYZ notice to your clients. However, The bar rules do, of course, cover our duties to our clients, and so you want to look very carefully at that. I will talk about notice in general. You have a duty, just under the general bar rule, our professional responsibility duty, to notify our clients if you're closing a practice. And one of the questions that came up before we started the webinar today was what to do with original documents, original wills in particular. And many attorneys keep original wills. The trend, at least for me, I don't keep any original documents for this very reason. I mentioned that I haven't, my practice when I practiced in Maine, my firm in Maine had been around since the 1900s. And we had wills from people who were long dead. We know, but we couldn't get rid of them. So I vowed that when I had my own practice, I was never going to keep original wills for that reason. I did not want that responsibility. We had a vault full of them, and the receptionist would every day check the obituaries to see who had died in town, to see if we could try to track down some of them. So, and we were stuck with that. So that's a big issue that many of us are going to be facing, those of us who do keep original documents. So I do believe under the bar rules you have a duty, and certainly under the rules regarding destruction of files and the like, you have a duty to somehow address these issues. So I would say figure out what you want to do that makes sense to you, look at the bar rules and see if it's consistent, and then you might need to modify what makes sense for you. There was some discussion, for example, original wills, where you could file with them with the court. Well, that's great if you have 10, but if you have 500, that's a big issue. And I think also with filing with the court, that creates another potential problem for your clients, for example, because your clients are the ones who can only retrieve those. You can't retrieve them. So if you've now inadvertently filed a will that they have since modified, that may create a problem in the future.
Thank you very much.
Thank you. Good questions. Okay, so the last thing is how will that be accomplished? How are you going to accomplish your transition plan? So now we're going to get into it. We're going to get into the actual developing your transition plan. There are 3 components to your plan. And so like any plan, you've got the ideas. These are the things that come out of our minds that we say, this is kind of what I want to do. And that's what I want you to look at first with the list that we just went through, this other list. This is your mental planning list, okay? This is where you get quiet with yourself, chat with people you need to talk with, and I'm going to talk to you about a business team as putting your transition team together. During this phase, you're going to be beginning to put your transition team together. And as you're doing that, questions are going to be generated, and you're going to get this general outline of what you want to do. But then we get into the actual plan, the actual transition plan. There are 3 components. The first is intend. Second is the actual plan itself. And then the last is implement. I think we would all agree that what we intend, plan, and implement creates our reality in our lives. It does us no good to actually plan something and not carry it out. We won't create it. And I'm a personal believer in the power of intent. It governs your entire plan. So this is why I tell you to get quiet and figure out what you really want to do. This is one of those big life events in your life, just like the decision to marry, the decision to go to college, the decision to go to law school, the decision to go into practice in the first place. The decision to exit your practice is just as important. So get clear about what you want. You cannot plan well without knowing what you want. Otherwise, you'll be going down this bunny trail and then that bunny trail. You would tell your clients this. So in the same sense, whether we're doing estate planning or business planning or buying a home, this is the same thing that we tell our clients. It's time for us to do it ourselves in our practices. So get clear about what you want, and then set your intent that this is what I'm going to do. I intend to do this. And that's the first step in achieving your goal. The next is your plan. Of course, the plan is obvious. It's going to get us from point A here to point D when you disengage from your practice. So it's going to include the details. I always go back to the old who, what, when, where, why, and how. Okay? Those are really critical to keep in mind. Our plan components are these. Your stated goal. And your stated goal might look something like very clear. It might be very clear. And of course, the clearer you can make it, the clearer you can plan for. But I will go part-time at age 66. That is my stated goal for my retirement. And I will retire at age 70. Assuming I don't die or have a serious illness or those other things. So I would encourage you with your stated goal to keep in mind that the unexpected comes up. There could be an illness. There could be a sudden death. So you're really doing two plans. You're doing your plan that you intend, and you're doing your contingent plan in case that falls apart for some reason. Okay? One of the things that we baby boomers are running into, especially, is the plans that we make are sometimes now conditioned on what's going on with our parents. My parents have both passed on, so I do not need to worry about that, but I cannot tell you the number of business owners I have counseled in the past couple of years who were doing their plan for retirement, and then suddenly there became an ill family member or an ill spouse, and everything was thrown into some unexpected planning. They needed to, in fact, I can tell a story of what happened to me. I had two law partners, and Jeffrey Irwin and Lisa Kokos. They're wonderful partners. Lisa and I have been partners for a long time. Her husband left the AG's office and joined us. We were going gangbusters. Things were great. Jeffrey's grandfather has a very successful real estate investment company in another state. And he has assured the family he had a succession plan in place. Now, Jeffrey's mother is an attorney, and Jeffrey and his mom had been harping on him. He said, I've got it covered. You don't need to worry about it. Well, in fact, he did not have it covered. And his idea of a succession plan was to call Jeffrey when he became ill and terminally ill and say, Jeffrey, I need you to come home and take this over. So what do you think that did to them when they had just started a family and they had settled in here, they'd just finished remodeling their house, and suddenly they're being hit with, guess what, we're moving to another part of the country, and we're leaving. So the good news is we had a succession plan in place, so I can speak from personal experience how this could have gone if it had gone one way versus the other. Was that expected? Absolutely not. None of us did. It was not wanted, but it was really something he could not avoid. That is an example of an unexpected that we did at least have a plan in place, and we were able to weather the storm, and my firm has weathered it because of that. And I'm grateful to the fact that I had partners who were willing to recognize we needed to do things right. We were not the shoemaker's kids going barefoot. We walked the talk in terms of our planning. So that's an example of where I've learned firsthand that I can have my plan to retire at 65 and then go part-time at 70. Go part-time at 65, go full-time at 70, and anything can happen. Life is about change, is it not? But if I don't say this is my intent, I won't get there. So my stated goal is this, and that's what I designed my plan for, and I have this contingent plan on the side. So the next plan component is, how am I going to achieve it? Here's my big picture as well as my details. So perhaps let's take an example of the firm that is has four partners, and they have one associate, and the associate is awesome but has no business experience at all, has been practicing for 3 years. And we have 4 baby boomers with a Gen Xer, a younger Gen X, closer to the millennial. So this firm should be looking at how are they going to get to the place where, and they're all baby boomers, they're all around the same age, so they're all going to retire at the same time. They need to be looking at as a team, are we going to carry this firm on? Does anybody want to carry this on, or do we all want to just close shop? You can do that. But with a firm that size, there's definitely more value, perhaps, than a sole practitioner. Not necessarily, but more often than not. And you're going to get 4 opinions on what we should do, right? Put 4 attorneys in one room and ask them to decide on something together. So you're going to get 4 different opinions on what we might possibly do. So, but this succession planning or this transition planning is something that the 4 of them need to engage in as a discipline. Because if they are serious about wanting to get some money out of the business other than their salaries for the years that they've been every year, their good salaries that they take home, then they need to start planning. And the plan would include bringing on younger attorneys. They need another generation in there. And I would encourage you to not only have X's, but to have millennials as well. Bring in 2 generations, because your Xers, even if you could have an older X and a younger X. So they need to decide, are they going to grow? Can they grow? How much do they want to grow? Is the person that they have, the associate they have, someone who is competent and likely to take over the practice? Or is that associate somebody who's kind of floundering, isn't sure what they want to do? That's not the good person to take over the practice. So maybe that associate's not the right fit for the firm in the long run. So either they need to bring someone else in with the idea that this person is going to be a good fit and hire for that, So sometimes you hire for different things. When you're getting ready to do transition planning, you hire for your successor. You're not hiring for the competency and the skills necessarily. So you're looking for a broader skill set. They don't have to be competent in managing the business. They just have to have the ability. And not everybody does. I'm sure you've all had an associate or two in your career who wasn't good at the business end and didn't want to do that. They would make a fine government attorney, make a fine prosecuting attorney, whatever, be great in corporate, but they really weren't interested in managing the business. So as you're starting to think about this, let's say this firm of 4 attorneys, they want to interview that person, try to find out, are you interested in the business? Do they have an interest? And if so, then they're going to want to start doing the mentoring and start grooming that person to take over. And you have to offer the incentives, because now we don't want the person to leave, right? Because this is now, and you have to be aware that things could happen in their lives. Suddenly the mother in Maryland is dying, and this attorney who you've put all of your eggs in this basket is disappearing. So we have to recognize that the world is changing and our plans can change. But the idea is that we move forward with as best effort as we can, and it's best to have contingencies within contingencies. So if, for example, you put your eggs in one basket of an associate, it's best if you have a second as a backup. Okay? So how you're going to achieve that goal is going to be dictated by what you're trying to do, obviously, but you need to start putting those pieces together and thinking about the things you need to, that will get you from point A to point D. So who will assist you in your transition is what I call your transition team. Your transition team should consist of your bookkeeper, your CPA, a business consultant at a minimum, and possibly a lawyer if you don't do this kind of work. If you feel comfortable that you can do all the legal work yourself, great. If not, find a colleague that you trust and like and have them help you do the legal work when the time comes. But at a minimum, why your bookkeeper and your accountant and your business consultant? The bookkeeper and accountant are going to work on those pristine financials, right? And when I say your bookkeeper and your accountant, I'm assuming that you've got a dynamite team, that those two already talk and communicate, and that your bookkeeper is not somebody who just does data entry, that your bookkeeper really understands your financials. And I'm assuming that your CPA actually reviews your financials every year at least. My CPA comes in quarterly and reviews everything with my bookkeeper and me. I meet with my bookkeeper monthly. We go through the financials. My associate and I go through our financials together because I want everybody to be on board of what the health of the firm and where are we on every issue. Not everybody's willing to do that. There's this old, we keep all this stuff to our chest and we don't share it. If you're going to sell your business to someone coming up behind you, you owe it to them and to yourself to get them to understand the finances of the business. If they don't understand the overhead and why things cost as much as they do, then later on they're going to be totally in the dark. Right? And there are things that they may see that you don't see. Well, we could lower expenses this way, or we could increase rates or do whatever. So those are part of your transition team. Now, your business consultant, there are a variety of business consultants. There are the numbers business consultants. I actually have 2 consultants. I have one who's the numbers guy, who is very helpful for things like projections. He's my numbers guy. But then I have my warm and fuzzy. My warm and fuzzy is the one who works with my staff, works with me, works on making sure that our policies, procedures, and I'm not talking about your policy manual. I'm talking about your practical procedures manuals, our practices, what's working, what's not, keeping us working as a smooth running ship. That's where your business consultant will come in handy to help you figure out how to position your business for a sale. So when you're interviewing business consultants, you want someone who understands ideally a law office or at least a professional office. And ideally, I would think that for this practice, you want somebody more the warm and fuzzy side who's going to be able to help you put your practices and document your practices. Even if you don't have them written down, you've been doing them. Your staff have been doing them, even if you don't know what they are, but they need to be documented. And that person can also help you evaluate whether you own your job or own your business. So when I talk about this transition team, you also might include a business broker if you decide you want to sell. And even if you think you might want to sell, you're not sure if you're going to sell internally or externally, I would recommend that you consult with a business broker. They will typically meet with you and be willing to pay them for their time. They're giving their expertise. But meet with a business broker and say, this is what I'm looking at. I don't know about selling a law practice. Tell me what you know. and interview a couple and find the right one who says, yes, I've sold law practices, and what do you have? And then let your business broker and your business consultant talk, because they'll be able to figure out what are the missing things you need to do to get your position ready for sale or for transition. Okay? Your plan's also going to say the time frame, when you're going to implement the plan and when you expect to complete your transition, as well as the timeline for your action items. So, for example, you might say, we're going to take the next year and a half to document our procedures and to clean up our financials. It doesn't need to be June 1st, we're going to have this deadline. Don't make it so hard on yourself, but say we're going to take a year. By June of 2014, we want to have this task done. And then you work within that time frame to develop, okay, what are we going to do first? Do you want to do the financials first, or do we want to do the documenting, or do you want to do it at the same time? But either way, you're going to want to have some kind of a time frame to keep you accountable. Now, the other reason I like your transition team is that they hold you accountable. And one of the questions I've given this seminar, similar seminar for business owners with the transition team that I work with, and one of the things that I start seeing is the overwhelm sinking in. Around this time of the conversation, where it's like, oh my gosh, I have to hire all these people to help me do this. So I want to take a step back and say, you don't need them all at once. But what you want to do is have them in place to say, these are the people that I want to work with. These are the people I trust to help me through this process. And you might work with your business consultant initially for a 2-month period and then go off and do your thing and not see him for a year. You might meet with that business broker and have a conversation, a couple-hour conversation, done. You might then meet with your bookkeeper for hours on end working on financial issues, but then you don't need your attorney for 5 years. But the key is that you want to really pick who your transition team is, because when you need them, you want to spring them into action, and you want them to know that they can talk to each other. And your timeline for your action items, I think the business consultant is someone you want to keep on board as on a regular basis, and set yourself up for saying, we're going to have quarterly meetings or semi-annual meetings, maybe annual for the first 2 or 3 years, and as we get closer, then they become quarterly as you start transitioning. Because that person, and ask that person to hold you accountable. You want him or her to do that. Okay, so now we've got our plan in place. I'm going to encourage you to write that plan down. Get it in your head first. You might have little pieces of it written on paper, but get it into a written plan, much like a business plan. And we all know we're supposed to have a business plan, but many of us don't. And this is, again, the shoemaker's kids going barefoot. This is your opportunity to make a different choice as you transition out of your practice. So have a plan for this. It will go a lot smoother if you do it in a methodical manner. Now, keep in mind, we are all trained to be linear thinkers, are we not? This is not something you can't do. You can do this. It just means that you've got to do it. So now we get to the implementing part. It's going to take discipline and commitment. And the commitment piece is that if you can't be disciplined and committed on your own, either you have a key staff member. I have an office manager who rocks. She does not let me off the hook on anything, and I hired her for that reason. I knew she would be that way. I love it because I'm busy. I'm always on the go. And that's how I practice. I'm busy. I'm always going. And I have a lot of fingers and a lot of pies in the community. So I need someone who is going to say, you've got to deal with this today. Okay, thank you. Do I fight with her? No, I listen to her. So if you don't want to hire a business consultant to do that, find a key staff member from within who understands you, respects you, loves you, and wants to help you through this transition, and who you will reward as you go along the way financially so that they feel that they're compensated for helping you with this, and that in the context of that, get them to hold you accountable. Have them work with your business consultant as necessary so that you, on the pieces that need to be done, such as procedures or whatever. You're going to have some tough choices along the way. And you're obviously going to have some challenges. You're going to come up with that brick wall. You think you can sell your business, and then suddenly the reality hits in that there's no way you can sell the business the way it's structured right now. You've got to do something like form an LLC, or you've got to get those procedures in place, or you thought you had great financials, and now you found out they're a disaster. Well, and by the way, let's go back to the financial piece. If you want to get a good take on whether your financials are good, talk to one of your banker friends. You must have a client or a friend or a colleague who's a banker, or your own banker. take your financials into your own banker and saying, you know, I'm starting to think about transitioning 5-10 years. What can you tell me about my financials? Anything that make you concerned? I want an honest opinion. And they'll tell you, well, yeah, you know, your ratio here is not good or whatever. Or I can't even figure out what your ratios are because you don't even list the information in a way that I could be able to figure that out. That's a great place to start if your bookkeeper doesn't know. And I had started to say that if you find that you don't have a bookkeeper or an accountant who either talk to each other or who don't do this, it might be time to change. Or you might hire, like for example, you have a great bookkeeper who does the data entry, but maybe what you need is a bookkeeper consultant who will get your books set up the way they need to be set up and just basically consult with your internal bookkeeper or your contracted bookkeeper as needed, okay? So you can either do this consciously or you can leave it to fate. I'm going to encourage you to leave it in your own hands because that's where it belongs, and make good choices, and don't be afraid to change your choice, and don't be afraid to close your doors. It might be the best choice for you. And don't be afraid to have those hard conversations. This is all about stepping into that place of where I'm going to do this right. I want to do this well. You've practiced well. And as we start to think about exiting our practices, we want to exit that well too. Okay, questions? I've got one back here from the audience. Yes.
So I wasn't sure if it was me or someone else you were pointing to. So from online, I have a very specialized practice helping insurance agents around the country transition their agencies internally or externally. Neither of my two partners is interested in taking over my practice. I want to preserve for my client base my thousands of specimen documents and knowledge base. If I bring in a younger associate interested in this narrow specialty and do an earn-out over time, what percentage of revenues from my client base over how many years might be reasonable to receive from my buyer? I've seen 20% for 5 years before, for example.
Mm-hmm. Well, without looking at your financials in particular, I can't really answer that question, but you're on the right track. And so this is going to be an exploration. And for any of you, we were starting to think about this, well, what percentage is correct? It's an exploration to start with. So, for example, if it's going to depend on what your gross is and what your net is and what percentage is reasonable versus, and this is where good business valuation will come in handy, and a business broker or business consultant, CPA, or someone can help you value that and help you figure out that percent. That's exactly what they're designed to do. But you are absolutely asking the right question. And the idea of it being a specialized business, there are people out there who might find this an absolutely wonderful niche for themselves to be able to walk into something like this. It's good. Another question, I think? Yes.
Could you comment, please, on the role of goodwill, unsettled contingent fee matters, and accounts receivable in such a transaction?
Yes. Okay. So goodwill. Let's start with goodwill. First thing to do is that if you have goodwill in your business, if you're a partnership, then you want to look at your agreement to see. If you're a solo, then that is absolutely going to be a component of the value of your business. So if you've been open for 2 years, obviously your goodwill is a lot less than if you've been open for 30. That is, again, where your business, the business valuation is going to help decide what that value is. And typically it's going to be in part based on the number of clients you have, and the other component of that is how much you're generating from that. If you are generating a high level of income from that, your goodwill is going to be a higher number. It's going to be valued at a higher number. If you're generating a lower number, or if you have then dollar take-home pay, then it's going to be a lower value for goodwill. And it just because the number of clients can make a difference, because maybe you have a select group of clients like the person who has the select insurance brokerage firms and agencies, a select group might be fewer, but actually the goodwill might be higher. So it's one of those questions that has to be explored, and it needs to be. And then the other two parts of your questions again?
Unsettled contingent fee matters at date of sale.
Mm-hmm. Okay.
Jessica,
so
I will need you to repeat that since you didn't have a mic.
Yes. Okay, so the other two parts of that question were the unsettled contingent fees and also accounts receivable. There are two broad ways of doing this. There's other creative ways too. You can do a percentage and the like. But the broad way of doing this is that if I sell the business, you get the AR, the accounts receivable, from the day of the sale. that the buyer gets that. Why? Well, because that's part of valuing the business, is the accounts receivable is part of the valuation of the business. So they're paying for it. So they get all the accounts receivable, and in fact, they need that accounts receivable because you've now exited, right? And so they would then need that accounts receivable to be able to pay you. So it's generally that's how that's handled. The other way you could handle it is, I've seen it done as a percentage of, I get so much percent, or all the accounts receivable up to this date go to me. So, for example, if you're selling the assets, you'd keep all the AR. But if you're selling the business, typically the AR stays with the business. And then the last part of that was the contingent cases. Typically, that would be handled the same way it would be handled if you were going to refer out the case. So let's say you did half of the work, and now, to make it easy, and now for some reason you couldn't continue with the case, so you referred it to a colleague, and now that colleague takes over and settles the case. So typically you would handle it the same way on the contingent cases. I would recommend you look case by case. If your business is all contingent cases, you might want to come up with a blanket percentage. But before coming up with that number, I'd recommend you go through as many of the cases as possible. Let's say you have 50 contingent cases hanging out there, and figure out roughly the percentage of where those cases are. Are they at the beginning? Are they in discovery? Are they ready for trial? And if they are in the beginning phase or the ending phase, obviously your percentages are going to change, right? So if you could get a ballpark idea of where they all are, you might be able to come up with a blanket average percentage. Otherwise, you probably should value each of those individually and come up with an agreement. One more question from the home audience.
If I close my solo practice, not sell it, what trust account reporting procedures will the WSBA require of me? And will that differ if I sell the law practice? Now, again, I realize you're not representing the WSBA.
Yeah. There are two different ways of looking at that. First, with your trust accounting, you're going to need to keep a very clear audit trail for audit purposes of everything that happened, and that you've closed your account, and you're going to need to report that in your annual reporting. There may be a separate rule on that. I don't recall specifically a rule that addresses closing your client trust accounts, but when you close your practice finally, but you would definitely need to keep those records for a minimum of 7 years, just like you would for IRS purposes. Now, if you're transitioning out of the firm into another, you're transitioning out of the firm and your firm is continuing, well, that is taken over by those who follow you, your successor. And obviously, if you've got any unclaimed funds, I had this for the first time, somebody I couldn't find. We had some unclaimed funds. There's a provision in Washington law that if you can't track down somebody who has money left in trust to give it back, you can send that into unclaimed funds. And that's what you should do with it. And you just need to document that you did that and how you did that, et cetera, et cetera. Okay, I think we're just about out of time. Any last questions? That's great. Great. Thank you all. I appreciate it. And I'll be around for questions.